We're going to start a new section, that is section 10 of Income Tax Act. Income which is do not form part of total income. It is the largest section. Okay, it goes more than 1 or 2 hours, but please. So if you understand what is the income is not going to be charged under the income tax. If you're going to start a business, you can focus on this part mainly. If you focus on this part, you don't need to pay a single penny as tax. Section 10. Income is not forming part of total income. In computation of total income of various previous year of any person of any income falling within the following clause shall not be included. What are these clauses? Agriculture income. First one, agriculture income. Any part which is received from agriculture income is no need to pay a single rupee tax. Subject to the provision of subsection 2 of 64, any sum received by an individual as a member of Hindu undivided family who where some such sum has been paid out of income of a family, or in the case of an impartiable estate where such sum has been paid out of income of the estate belonging to the family. So any income which comes from the individual of a member of Hindu and family. So under section 64 or section 2, section 4. Section 64, what does it say? Income of individual to include income of spouse, minor, etc. So in individual to include income of spouse, minor, and etc. At section 64, section 664, subsection 2. Subsection 2, what does it say? To a spouse of such individuals by way of salary, commission, fees, or other form of remuneration, whether in kind of cash or kind of concern in which individual has substantially interest. Nothing is in clause shall apply to relation to any income rising to spouse where spouse possesses technical or professional qualification and income is solely attributable to the applicable of his or her technical and professional knowledge of expertise. This is very important. Okay, so in that case, any money individual which is money which received from that individual family is paid out of the family income, and that is taxed in the HUF. When the money which received from HUF to the individual, such income is not taxable because already it is been taxed in the hand of HUF. In the case of being a partner of a firm which is separately assessed in such share of total income of the firm. So as a firm, the income is taxed under 30%. So when the same income is being part of the income is taxed under the partnership firm or a firm or LLP, then the same amount which is received by the partner, it's not taxed in this hand. Okay. For the purpose of the clause, a share of partner of the total income of a firm separately assessed was should be separately assessed. That is, income tax to be properly paid, notwithstanding anything contained in any other law. For the amount is bear to total income of the firm of such proposition as the amount of his share in his profit of the firm is accordance with the partnership deed bears to such profits. It's a most important thing. Fourth point, in the case of non-resident, any income by way of interest on such securities or bond as the central government may be notified in official gazette specifically in behalf of including the income by way of premium of redemption of bonds. So the premium on the redemption of bonds or any bonds, the central government may, what they will do, they will disclose in this official gazette this income, interest income which is arising out of these bonds or tax free. Such a way central government will say for who, in for case of non-resident, not every resident, for non-resident this is in allowed. In the case of individual, any income by way of interest on the money standing to his credit to non-resident external account of bank. So same thing applies to the person, not only bonds, the interest income which is accrues by the individual, what is payable to the non-resident and under the FEMA regulations, Foreign Exchange Management Act rules. You can see if that regulates in any bank of India. So what you saying is individual any income by of interest on money standing to his credit in non-resident account in any bank in accordance with the foreign exchange rules center. Provided individual is a person resident outside India in defined permanent under Reserve Bank of India to maintain a aforesaid account. What happens? You are a resident outside India, but you have an account where in India or outside India, and you earned interest on that money which is outside India. You are outside India. Then the income doesn't accrue arise in India. You don't need to pay tax. That's the point is being clarified. In the case of individual, being a citizen of India or a person Indian origin who is non-resident, any income from interest such savings certificate issued before 1st day of June by central government may be notified in official gazette specifically provided an individual subscribe to such certificate in convertible foreign currency remitted from the country outside India according to the provision of foreign. What happens is some individual are subscribed to what? Saving certificate, deposit saving certificate, and he is in earning income accrue arise in India, but it should be issued before 1st day of June 2002. If that being the case, that income is exempted. If not, it's taxable. If not, it's taxable. So you can understand that. So it's outside India, it's not taxable, but it's in India, it's taxable. Any person shall be deemed to be an Indian origin if he or either of his parents or any of the grandparents are born in undivided India. For this purpose of the clause, the person shall be deemed to be Indian origin. So the person can be deemed to Indian when if he or either of his parents, father or mother, or any of his grandparents, fathers, father, mother, mother's father, mother, who are born in undivided India. So even though for the purpose of the clause to consider this income is not taxable, it's going pre-independence also. Convertible foreign exchange means a foreign exchange which is in a long period, long being treated as treated by the Reserve Bank of India as convertible foreign exchange for the purpose of Foreign Exchange Management Act 2009. Okay. In the case of individual, the value of travel concession assistance received by him due to him from his employer or himself or his family in connection with the proceeding on leave to any place of India. So that is an individual who is having travel concession. He is going to travel somewhere, and the employer has providing to himself or his family in connection to the leave travel within India. Then that income is exempted from his employer or former employer for himself and his family in connection to the proceeding to any place in India after retirement from services or after the termination of service. Maybe the employer may provide some allowance, leave travel allowance in case of any leave concession, even though he may have removed from his employment. Employer can provide to his employee after the retirement of service or after termination of service. Even he terminated himself, he can provide such a leave travel concession, and such thing provided by the employer to employee is to him and himself and to his family is exempted from his employer to employee to after the termination also is exempted. This point is very important. Such subject to such conditions as may be prescribed, including conditions as to the number of journeys and the amount shall be exempted after head. Having regarding to travel concession or assistance granted to the employee of central government. Have regard to the travel concession or assistance granted to employee of central government may be prescribed. So for central government also this applies, no problem. Provided that the amount exempt under the clause shall in no case exceed the amount of expense actually incurred for purpose of travel. So what is the amount which is received by the employee from the employer during the travel for himself and his family, rather after the retirement or after the termination, whatever the amount spent, he can claim from the employer. That is exempted. Other than that, anything he got, it will be taxable. For the purpose of family in relation to individual means, what is a family? Family has been defined. Spouse and children of the individual, parent, brother, sister of the individual, or any of them wholly or mainly dependent on the individual. So the family definition is given as per income tax, that is his spouse. Husband means wife, wife means husband, and the childrens of individuals. For them, their childrens and their parents, father, mother, and son's father, mother, and wife's father, mother, brothers and sisters of the individuals, of such individuals, husbands such individuals, and wives such individuals, of any of them wholly or mainly dependent on the individuals, any person or individuals, or any of them, brothers and sisters who are there also family, and any brother and sister wholly dependent of them are also considered as family. In the case individual who is not a citizen of India, so any person who is not a citizen of India, then the income is not taxable. Remuneration received by him as an official by whenever name called of the embassy, high commissioner, legation, commission, consult, or trade representation of a foreign state, or the member of the staff of any of the official was office of the capacity. Provide the remuneration received by him as a trade commissioner or the official representative in India of the government of foreign state, not holding office such of an honorary capacity, as the member of the staff of any of the officials shall be exempt only if the remuneration of corresponding official, or as the case may be, the member of the staff in any of the government resident for similar purpose in the country concerned enjoying similar exemption in that country. So what happens? These officials who are appointed as embassies in the high commission, legations, commissioners, they enjoy a single commission on the trade and respecting India. So this act says even though you are in other country representing in our country and you are getting some commission on this trade, this only exempted only it is exempted in the same country. The DTA provision applies. If not, you need to pay tax. Provided further, such members of the staff are subject of the country represented and are not engaged in any business or professional employment in India otherwise than the member of the staff. So you want to clearly say, even though you get the commission, that is only exempted when you don't practice anything, because even though you provide the service, you have a professional employment in India otherwise than the member, then such income is taxable. The remuneration received by him as an employee of a foreign enterprise for service rendered by him during the stay in India, provided following condition fulfilled. So there is a remuneration which is received by the employee of a foreign enterprise. So foreign company you are working for a service rendered by him, or you are staying and you are providing such rendering some service by him by staying in India. So some conditions to be satisfied to say that income is exempted. The foreign enterprise is not engaged in trade or business in India. So you are providing some service to them on behalf of them. They are not having any trade or business in India. His stays in India doesn't exceed the period of 90 days in a previous year. And such remunerations are liable to be deduction from the income of the employer chargeable under the tax. Any remuneration is not liable to be deducted from the income of the employer chargeable and tax. Okay, so the three conditions for the remuneration received by him as an employee of the foreign enterprise. You are employee of the foreign company, you are rendering service rendered by him while he is rendering some service in India, provided that the foreign enterprise don't have any any trade or business in India, no trade, no place of business, and his stay, the employee stay in India does not crosses 90 days. He is a non-resident, and such remuneration. So then if these conditions are there, and such remunerations not liable to deducted from income of the employer chargeable under the tax. The clause 8, any income charge under the head salary received by or due to any such individual being non-resident as a remuneration of service rendered in connection with the employment of foreign ship, where his total stay in India doesn't not exceeds the aggregate period of 90 days. So all this comes with the residential status. A non-resident who come to India and work in a foreign ship, and he stays in India not greater than 90 days, then his income doesn't, even though he gets his salary from India or some connection with them. For example, there is an we have a ship. That ship has been in Indian waters, in 200 nautical miles is inside it. The ship was broken. So now we need an engineer who is in Germany. We're calling him. He comes to India, stays in India, and make brought all the missionaries and doing a service and going back. In this case, we should see whether the Indian companies need to pay salary to him. Yes, they need to pay salary to him. So due the individual is a non-resident, yeah, he's non-resident, but remuneration received or entered in connection with the employment, because this such employment is toward a foreign ship, not an Indian ship. Clearly says such thing is also foreign ship, not an Indian ship. If you want an Indian ship, it's different. Akrun arise in a foreign ship, but he stays in India, not cross 90 days, then no problem. No need to pay any tax. A remuneration received by him as an employee of the government or foreign state during the stay in India in connection with the training of any establishment or office or in any of the foreign governed by. So there is a remuneration received by the employee of foreign government. Some foreign person staying in India in relation to training of any establishment or office in understanding owned by that government or any company in which entire paid up capital is held by the central government or state government or government partly by the central government or partly by the state governments, or the owned by the government of foreign state. The government here is totally saying the foreign state, okay, not Indian state. Any company in a subsidy of the company referred under subsection 2, that is a paid up capital of the central government and state government or both, or any corporation established by under the central state provincial act, or in a society registration under Society Regulation Act 1980s, or under the corresponding law in the time being forced wholly financed by central or state governments, partially central or state government, one or more states. So that is a this clause 9 says the remuneration is received by him who as a employee of a government of foreign state, employee of a government of foreign state, and during stay in India in connection with the training in any establishment office or in any undergoing government by the government. So this state that our government or government companies which provide any service to a employee of an other government entity, then such remuneration received by him due to the stay in India, because he came in India, he's got trained by India, so that income is not taxable. Where in the case of foreign company deriving income by way of royalty or fees for technical service received from government or Indian concern in pursuit of an agreement made by the foreign company with the government in Indian concern 31st March 1976. Agreement related to matter including industrial policy for the time being in force, the government of India such agreements according to the policy, or in the case of agreement approved by the government. So there may be a policy or thing where the foreign government earn royalty of fees, technical fees from the government or Indian company that's owned by the government because of the industrial policy was being made, and such is being forced from but before first day of June 31st March 2019 76 to June 2002. Within this period, if they got any income, then it is not taxable. After that, it is taxable. And tax of such income is payable under the terms of agreement by the government of Indian concern. So, for explanation, the fees or technical service that means explanation of section 2, and foreign company ADB royalty means royalty. Where in a case of non-resident of a foreign company deriving income, not being a salary, royalty, technical fees from the government or Indian concern of pursuing an agreement entered before 1st June of 2002 by the central government with the government of foreign state or international organization, tax of such income is payable by the government or Indian concern of central government under the terms of the agreement or under the related agreement approved by the day central government or tax so paid. Okay. Not a great deal. So In case of government of the foreign state or the foreign enterprise deriving income from an Indian company engaged in business operating aircraft as a consideration of acquiring an aircraft or aircraft engine. So they are acquiring aircraft, the acquiring aircraft engine. Other than payment of providing spares, facilitation service, a connection with the operation of leased aircraft or lease agreement. The agreement entered on 31st March 1997, but before 1st April 1919, entered in often the 31st March 2007 approved by central government on its behalf. Tax on such income is payable by such Indian company under the terms of the agreement of central government, so tax payable also. Okay. For this purpose, a clause agreement, foreign enterprise means a person who is non-resident. 1C6C, technical services, everything. So that's not so great point. The same point. Seven. Any allowance or perquisites paid or allowed as such outside India by a government towards citizen of India for rendering service outside India. So who is paying India? To whom is paying citizen of India? Where it is paying outside India? Why? For rendering service outside India. So Indian government is paying to a Indian citizen for service to be rendered outside India. Then such paid allowance and perquisites or only allowances and perquisites are not taxable. Salary is taxable. In the case of individual who is assigned to duties in India in connection with any cooperative technical assistance programs or projects in accordance with the agreement entered into by the central government and the government of foreign state. The terms further provided that exemption of the clause. Remuneration by him directly or indirectly from the government of that foreign state of such duties. So here is an individual who is assigned duties in India in connection with the corporate. So for technical support of program or project, he is been assigned for agreed period of time by central government and foreign. For central government of Indian employees appointed in the foreign state, and he is receiving some directly or indirectly some remuneration from the foreign state, that is exempted. And any income such individual which accrues and arise outside India and it is not deemed to accrue arise in India in respect of such individual is required to pay any income or social security tax government of the and foreign tax. Yes, any other income. So other than this, some income he may arise and such individual accrue arise outside India and it's not deemed to accrue arise in because it is also deemed accrue arise in India in respect of which such individual is required to pay any income or social security tax to government of that state. So this points are saying if other than such income which is accrue arise in India outside India, then he required to pay income tax or social security tax to that government of foreign state. He need to pay that tax. Okay, and that income is not exempted. So even though section says exempted income, that doesn't mean that he is not required to pay tax. We not required to pay tax on that income. That is exempted income in India, but such income is exempted. But only in the case he is been assigned that on that period, that income should be erased. In the case of consultant, any remuneration of fees received by him or it directly from him or it program directly or indirectly out of a fund made available in an international organization. However, reference to the clause 80 of agency under the technical assistance grant agreement between agency and the government of foreign state. There should be an agreement between our government and the foreign state. Then such consultancy fees what you receive directly or indirectly from through or it that fund available from the international organization is exempted. And any income which accrue arise in India and in or it outside India, it's not deemed to accrue arise in India in respect of such consultations required to pay an income or social security tax to government of the country of its origin. So in that says also any other income which is arising from it is taxable in that country. Any individual who is either a citizen of India or not being a citizen of India, not being a citizen of India, it's not a citizen of India. It's not ordinary residents of India. The consultant can be resident, non-resident or non-ordinary residents. or any other person being being non-resident can also be a non-resident. Another person, that means it can be company, it can be any LLP, trust, AOP, BOY, anything engaged by the agency for rendering technical service in India in connection with any technical assistance programs or project providing following condition fulfilled. The technical assistant is in accordance with an agreement entered into by the central government agency. So any technical assistant to be provided, there should be agreement between whom, our central government and the agencies. The agreement relation to the agreement of the consultant is approved by the prescribed authority for the purpose of the clause. So such consultant to be approved, not a technical assistant should be approved first, then such this for this contract agree, the agency and the central government agreed, okay, we going to provide, and who we going to appoint also, this consultant that should be engaged in the agreement, that is also to be approved. So there's two things to be approved before. If you don't see these two agreements, such income which accrue from arising out of this consultant income, it's taxable. In the case of individual who is assigned to duties in India in connections with the technical assistance of program or project in accordance with the agreement entered into by the central government agency. Oh, there is an individual who is assigned to duties in India. So some individual, that maybe he is a non-resident or ordinary resident, any person which is annexed to the technical assistance program, he is engaged in India and he is receiving some remuneration directly or indirectly for such duties which consulted under the clause 8A. Okay, and other income which is the individual is accrued or arise outside India, it's not deemed to be and what are the income which are arising outside India, it's not deemed to accrue arise in India, in respect of which such individual required to pay on income or social security tax to the country of his origin, provided the following conditions are fulfilled. That is, individual is an employee of a consultant, it should be employee, should be employed of a consultant, referred under clause 8 and either not a citizen of India, being a citizen of India, or not ordinary citizen. The contract of service of the individual is approved by the prescribed authority before the commencement of service. So the same thing. So whatever the income which is accrue arise in India is exempted, and if it is other than this services and such incomes accrue and the tax to be paid. They clearly saying only the service you enter it's exempted, not you can do business and anything extra. Things are taxable. Only connection to this consultancy, the remuneration what you receive exempted. Section 9, subsection 9 often. Income by of any member of a family of any such individuals as in refer to clause 8 or clause 80, as a case may be clause 8b, accompanying in him to India, where the accrue arising outside India is not deemed to accrue arise in India. In respect of such members are required to pay any income or social security tax to the government of that foreign state. Thus comes a problem because the residential status may come to question. Even though he is not in India, but when he comes, as example, Indian government required some service, very technical service, a cyber security service, and we recruit someone from outside India, but he comes to India, he stays in India, then he goes outside India. But when he stays in India, his period of month has crossed 6 months or 9 months, whatever period. When a question arises now, rather he need to pay tax, and what become our ordinary resident, do he has a problem of showing all the income which accrue outside India need to pay in India? No, they have given exemption for them only if that person and the agency and central government has done agreement and that person is being approved by that approved. If these two things is there, no problem. Okay, section 10I. Any death cum retirement gratuity received under revised pension rules of central government, or in the case of central civil service rules, or any similar scheme applicable to members of civil services or union or holders of posts connected with the defense or civil post on the union, or such members being person not governed by these rules, or to the members of the all India services or the members of the civil services or stakeholder civil post under the state, to the employees of the local authority, or any payment of retiring gratuity received by the pensional code or regulation applied to the members of defense service. This all states two things. What is civil service and the military defense persons who had received retirement benefits, and the same time death come retirement benefit. If this two has received, it is totally exempted under section 10 subsection 1. Any gratuity received by the Payment of Gratuity Act 1972 to the extent does not exceed the amount calculated under the provision of section 2 and 3 of section 4 of the act. So section 4 of the act says any gratuity amount which is received more than 10 lakhs, I think so, that is not crossing that amount until below that 5 lakhs and 10 lakhs, that amount below that is exempted. More than that is taxable. That's what say. You can say section 4 of that. Charge of income tax. So the central government enacts total income to charge in any assessment here, the rate. So on that rate we charge, and that here section 4, okay, of section 2 and 3. Charge of income tax, right? Oh, sorry. Payment of gratuity. Under the payment of gratuity, yeah, section 4 and section 2 and 3. You want to see that section, not income tax act, okay? So any other gratuity received by the employee on his retirement or is becoming incapacitated prior to such retirement or termination of the employment, or such gratuity received by his widow, children, and dependent on the death, to the extent it does not, in the case, exceed 1/2 month salary of the period of complete service, calculated on and the average salary of the 10 months immediately preceding the month on which it occurs, subject to the limit of central government may notify an official gazette specified in the behalf of the limit applicable in his behalf of the employees of the government. What happens is that, like, gratuity will be given 15 days of salary, which is calculated in the average of last 10 months working, and this 15 days salary will be calculated for considered as a 1 into number of working years. That is minimum of 5 years, and how much years he had worked into that years of service. If you multiply it, you will get a gratuity amount. Such amount which you received is exempted, and sometimes the central government may prescribe a limit. Up to this amount is exempted. More than that amount what you received is taxable. Provided that gratuity refer to the clause are received by employee from more than one employer in some previous year, the gratuity amount exempt from the income tax under the clause and shall not exceed the limits of. So the question is, what if this gratuity amount received from two employers? Employee can work for both employees and he got a salary gratuity from two employees. What has happened? So they exempt for two cases or single case? That question, na? So gratuity regarding received by employer from more than one employer in the same previous year, the aggregate amount of exempt from the income tax under the clause shall not exceed the limits of. So if the limits say only up to 10 lakhs, only 10 lakhs. Both employees you put together 10 lakhs. In they have clearly in same previous year. Okay, in different previous year you can put same time, but if you retain the same previous year, there is no availability of that provision. Provided further, where such gratuity or gratuities was or were received in any one or more earlier previous year also, and whole or part of the sum of such gratuities was not included in the total income assessed such previous year or years, the amount exempt from the income tax under the clause shall not exceed the limits of reduced by the amount, or as the case may be, aggregate amounts not include the total income of such previous years. Or so they clear what happens in that case. I will create it this year, next year I get this amount. He thought so. That not like that. It's totally, you can get the gratuity amount exemption this much only, but central government employees totally exempted. Only for the private employees, the limits of gratuity is there. Other things aren't there. So we can stop from this and we will see in the next video. Bye bye.